In court, momentum often looked permanent until one careful cross-examination changed the whole soundtrack. Prosecutors built narratives, then one answer cracked the certainty on live television. 10 moments proved the defense only needed a single opening to flip the room, when defense attorneys made prosecutors regret every question. If courtroom history was your kind of late-night comfort viewing, hit subscribe and keep these real-world turning points coming. Number 10. O.J. Simpson. The most dangerous thing in a courtroom was a visual the jury could never unsee. On June 15, 1995, prosecutor Christopher Darden had O.J. Simpson try on the bloody gloves in front of jurors, with latex gloves underneath, betting the demonstration would feel definitive. Instead, the gloves appeared not to fit cleanly, and defense lawyer Johnny Cochran turned that moment into the simplest kind of doubt, the kind that stuck. The backfire was bigger than one awkward minute. A staged prosecution exhibit became a defense symbol, replayed for months on television. Simpson was acquitted on October 3, 1995, later found liable in a 1997 civil case, and he died on April 10, 2024. The lesson stayed timeless. Prosecutors regretted questions that created defense exhibits. Number 9. Kyle Rittenhouse. Sometimes the regret arrived before the next question even finished. During cross-examination in November 2021, prosecutor Thomas Binger pressed Kyle Rittenhouse about his post-arrest silence. Judge Bruce Schroeder stopped the exchange, excused the jury, and sharply reprimanded the prosecutor, calling the line a grave constitutional violation. For the defense, the judge had just told jurors without them in the room that the state had stepped into forbidden territory. When the jury returned, the courtroom mood had changed. The defense did not need a long speech, the prosecution looked risky and impatient, and the judge had made that impression stick. Rittenhouse, age 18 during trial, was acquitted on November 19, 2021. Number 8. Michael Jackson. A celebrity trial could turn on the smallest credibility fracture, especially when cameras were rolling. On March 14, 2005, defense attorney Thomas Mesereau Jr. cross-examined the teenage accuser in Michael Jackson's trial, pressing him on prior statements and shifting accounts. Under that pressure, the accuser acknowledged telling a school dean that Jackson did not do anything to him, a concession that landed hard because the prosecution needed steady certainty. That was the kind of answer prosecutors could not easily unring. It changed the framing from a clean narrative to a credibility battle, and the defense stayed on that ground for weeks. Jackson was found not guilty on June 13, 2005, and this cross-exam day became one of the best-known examples of the defense pulling a key thread in public view. Number 7. Casey Anthony. Forensics sounded like certainty until one technical claim started wobbling. In June 2011, prosecutors highlighted a dramatic figure, 84 computer hits they suggested showed repeated interest in chloroform. Then the defense undercut the punch. Using independent analysis of the same Firefox browser history the state relied on, the defense argued that the 84 count belonged to a MySpace page record inside that history, not the chloroform recipe page, which had only been visited once. A scary-sounding number turned into a disputed interpretation. Once that shift landed, jurors had permission to doubt the neatness of the digital story. The moment also showed why prosecutors regretted dramatic claims built on software logs and browser history, because the defense could reframe them as noise. Casey Anthony, age 25 during trial, was acquitted on July 5, 2011. Number 6. The Staircase, Michael Peterson. A case could survive bad optics, but it struggled to survive a damaged expert. In the 2003 trial of Michael Peterson, North Carolina SBI analyst Dwayne Deaver testified about bloodstain evidence in ways that supported the prosecution theory. Defense lawyer David Rudolph attacked the methods and assumptions, and years later the credibility problem became official. On December 14, 2011, Judge Orlando Hudson ruled Peterson deserved a new trial, finding Deaver's testimony was materially misleading. Peterson was released on bond 2 days later. That ruling changed the story of the case. The prosecution had relied on science like a closing argument. You could not argue with, then the defense helped show the science itself was the weak link. Peterson later entered an Alford plea on February 24, 2017 to voluntary manslaughter, receiving credit for time served, and the expert certainty moment became a long-running cautionary tale. Engagement break. Before we continue, which televised trial moment lived in your memory the longest? Did you ever leave court TV running in the background like it was late-night radio? Drop a comment and tell us where you are watching from, city and state. Number 5. George Zimmerman. A prosecution witness could walk in as the emotional center, then leave as the defense's best exhibit. In June 2013, Rachel Jantel testified in the George Zimmerman trial, and defense attorney Don West pressed her on memory, consistency, and language. The exchange over Trayvon Martin describing Zimmerman as a creepy-ass cracker became a national clip, but the bigger issue was the credibility strain the cross-examination exposed. The prosecution then had to spend precious time repairing impressions instead of building momentum. Once a jury started feeling uncertainty about a witness's reliability, every later detail sounded less firm. Zimmerman was found not guilty on July 13, 2013, and Jantel's testimony stayed a widely cited example of how prosecutors could regret putting a crucial storyteller on the stand when the defense knew exactly where to push. Number 4. Lyle and Eric Menendez. The first Menendez trial helped define trial by television, and that spotlight made every witness vulnerability matter more. Prosecutors leaned on therapist L. Jerome Oziel and recorded sessions to frame motive and admissions. The defense attacked Oziel's credibility and incentives, and the tape-driven storyline started looking less clean once cross-examination turned it into a dispute about ethics, influence, and reliability. The prosecution had opened a door, and the defense treated it like a hallway. The case later returned to the headlines in a very different way. On May 13, 2025, Los Angeles Superior Court Judge Michael Jessich sentenced Lyle and Eric Menendez from life without parole to 50 years to life under California Penal Code 1172.1, the recall and resentencing statute. Because the new sentence is parole eligible and both brothers were under 26 at the time of the crimes, they became immediately eligible for a youth offender parole hearing under Penal Code 3051. It was a reminder that in famous courtroom stories, the questions kept echoing for decades. Number 3. Oscar Pistorius. A timeline witness looked powerful until the defense made timing feel slippery. On March 3, 2014, neighbor Michelle Berger testified that she heard blood-curdling screams and then shots in the Oscar Pistorius trial. Defense advocate Barry Rue challenged sequence and certainty, pressing whether what she heard could have been misinterpreted in the moment. He did not need to prove she lied. He only needed jurors to picture how sound and panic could confuse memory. That kind of cross-examination forced prosecutors to defend their witness instead of simply using her. It also pushed the case toward competing interpretations rather than one clean narrative. Pistorius was convicted, and after years of appeals and parole proceedings, he was released on parole on January 5, 2024. The cross-exam approach remained a masterclass in turning confidence into cautious doubt. Number 2. Alex Murdaugh. Modern trials loved digital timelines because they looked precise on screen. In February 2023, prosecutors used cell phone step data to tighten the timeline in the Alex Murdaugh double murder case. Defense attorney Philip Barber cross-examined the state's interpretation, emphasizing that step counts did not directly measure distance and that speed assumptions could be debated. The effect was simple. The state's clean graphic started sounding like a chain of choices, not pure truth. That shift mattered because prosecutors wanted the jury to feel the timeline was locked. Instead, the defense made room for uncertainty in the same evidence that was supposed to end argument. Murdaugh was convicted on March 2, 2023, and the South Carolina Supreme Court heard oral arguments in his appeal on February 11, 2026, showing how long these data battles could live after the verdict. Number 1. William Kennedy Smith. Before streaming, one televised trial still showed how a defense lawyer could change the entire tone without raising his voice. In December 1991, the William Kennedy Smith rape trial played out in front of a national audience, and defense attorney Roy Black built his case through relentless cross-examination detail, pressing inconsistencies and forcing the prosecution to fight on the terrain of doubt instead of story. It was not one magic line, it was the steady accumulation of small uncertainties. That method aged well because it felt like craft, not spectacle. Smith was acquitted on December 11, 1991, and the case became a defining example of how televised courtroom strategy shaped public memory. Roy Black later became synonymous with that win, and he died on July 21st, 2025 at age 80.